Unexpected secular voices joined the rally on Wednesday, and as Mark indicated, it will take months before we know the outcome of this case, likely next June. If Roe and Casey are overturned or significantly weakened, 26 states, shown here in red, are poised to attempt to restrict abortion in some way as quickly as possible. Most of these states have laws or constitutional amendments already in place waiting to be implemented. Others have legislation in the pipeline to ban abortion if and when the federal ban to restrictions is overturned. At the core of the legal argument is viability of the unborn child in the womb. An op-ed in the Wall Street Journal by Dr. Grazie Christie addressed that issue. She joins us now to give us a medical take on what we heard from the justices. Grazie, it's so great to have you here with us. First of all,
thank you so much.
The article you wrote in the Wall Street Journal discussed what you called the obsolete science behind Roe v. Wade. Can you tell us what you believe are the differences between now and 1970 in neonatal medical care?
Well, so much has changed. To start with, the line of viability has moved drastically. Children as young as 21 weeks old, 21 in a couple of days, have survived. With extensive help from the neonatal ICU, of course. We've also had tremendous advances in our knowledge of fetal pain. For instance, we know that fetuses can feel pain much earlier than we thought that they could, even maybe up to 12 weeks, as early as 12 weeks, which is something that should give all of us pause. And also my own particular field, which is radiology. I do fetal ultrasounds, and that didn't even really exist in 1973. But now every little baby in America is imaged through ultrasound, and those beautiful pictures have changed American minds and hearts about the humanity and liveliness of the fetus.
And hopefully they'll have some kind of influence at the court. This issue of medical changes featured prominently in Justice Sotomayor's opening inquiry, where she first discussed fetal pain. Let's listen to her questioning.
There's about 40% of dead people who, if you touch their feet, the foot will recoil. There are spontaneous acts by dead brain people. So I don't think that a response to by a fetus necessarily proves that there's a sensation of pain or that there's consciousness.
Grazie, what's your response to her comparison?
Well, first I pity her because it's a really, really ignorant thing to say. But I feel sorry for her because she's not a doctor, she's not a scientist. On the other hand, I'm not sorry for her because what she's trying to prove is that fetuses, just because they're not born yet, don't deserve any care or concern for their pain, for the horror that they endure in abortion. And also, scientifically, she's completely wrong. When a brain-dead patient moves, it's a very specific thing called a spinal reflex. It's elicited in very specific ways, and it only happens because they're on cardiac support and respiratory support. This has nothing to do with the movement of any human being or any living being at all who feels pain and recoils from pain, which is what the Solicitor General of Mississippi was referring to when he was trying to get at the idea of fetal pain and how that should make us stop and love these babies.
And there was another aspect to the questioning that Sotomayor and Alito got into, and they talked about, with Solicitor General Scott, life at the beginning of conception as a religious view. Is it a religious view, a philosophical one, or a medical one?
It's a simple biologic fact that life begins at conception, and the nascent human life, that very early human life, is very distinct from the mother, has its own DNA, and is alive. We have biological markers for what constitutes life, and a fetus, an embryo, even the very first cell of a human being. They fulfill all those requirements, those biological requirements for life. So there is no biologic or scientific doubt as to when life begins.
Grazie, there were other scientific words used, viability and quickening. Those were the words of the day in the argument, where the Biden administration said the government has an interest in a baby's life only after viability. Can you explain that for our viewers?
Well, the other side, the pro-abortion side, wants us to only start considering that a baby might be worthy of protection after the baby can be put on life support in an ICU if removed from the mother. But that's a there's no philosophic basis for that or legal basis for that, really. All we're saying is a baby at 20 weeks can be killed legally, but a baby at 21 weeks can't be killed legally. There's no difference in that baby, except that right now, today, a neonatal ICU with intensive care 24 hours a day with an entire team of dedicated, loving people can keep a 21-week-old baby alive some of the time, but they can't at 20 weeks. Well, maybe in a couple weeks or in a couple years, that next baby will live at 20 weeks, born at 20 weeks. So the line of viability is, first of all, it's a shifting line. And second of all, it has a lot to do with your location. Do you have a great neonatal ICU near you? You know, viability in the United States is very different from viability in South Sudan by many weeks. So a child's worth should not be measured in terms of the kind of science and the kind of support that the baby needs to survive.
And this brings up many questions for us about access to care for marginalized communities. Thank you so much, Grazie. We appreciate your analysis.
Thank you.
For legal analysis of what happened this week at the High Court, we're joined by attorney Heather Hacker. As the former Assistant Solicitor General of Texas, she's argued numerous times before state and federal appellate courts, and she's represented pro-life groups in similar challenges and filed an amicus brief in this case, the Dobbs case. Heather, it's great to see you again. Thank you for joining us.
Thanks for having me again, Montse.
Justices Breyer and Sotomayor both began with their concern that overturning Roe and Casey would make the court look political. What are your thoughts on that?
Well, I think Solicitor General Scott Stewart hit the nail right on the head when he said that actually upholding what many people agree is erroneous or bad precedent is actually more political. Because if the court is only doing that because it fears the public reaction, then that's taking into account external considerations where in reality, under the stare decisis doctrine and just under the Constitution, the court should only be concerned with what the law is and should go from there. And so looking just at the precedent and deciding whether or not it should be retained or overruled, that's the question before them, and to consider other reactions, as the court did wrongfully in Casey, is actually the more political choice.
So looking at the history and where this right is grounded really tells us where the court should be going in a non-political way. It seemed the justices were looking for a way to replace this 30-year-old viability standard with something else. One of the things mentioned was expanding undue burden. What does that mean?
So I think that, the underlying problem with that, which I think that several of the justices seem to recognize, is that the undue burden standard itself is very malleable and really meaningless and arbitrary. And so, one problem they would have if they sought to just replace the viability standard with something else is that any other standard that they could choose would arguably be just as arbitrary as viability. If they, for example, chose to draw a line at the first trimester, then you would have some similar issues in terms of the workability of that standard, how that standard is justified. And then you still have the overarching problem of course, the Constitution still doesn't say anything about this.
And choosing where they're drawing these lines effectively has them legislating this issue. Am I right?
That's 100% correct. I mean, that kind of line drawing and balancing, that is the exact thing that the political process is supposed to be used for. And that's what's so negative about the Roe and Casey precedents is that it's essentially shackled the states to the court's view of, this issue, when in reality, the state legislatures are the ones that are supposed to be weighing these important interests and drawing these lines, not the court.
And so the discussion there wasn't necessarily one about legal issues, but wasn't necessarily one about being pro-life or pro-choice, but one about the legal understanding of this. And Justice Kavanaugh seemed to suggest that the court figuring out how to be scrupulously neutral on abortion was the ultimate task. Let's take a listen to what he said.
That this court should be scrupulously neutral on the question of abortion, neither pro-choice nor pro-life, But because they say the Constitution doesn't give us the authority, we should leave it to the states.
Sounds like something that might end up in an opinion. What do you think?
I think that's a very good possibility. And I think that he was absolutely right to point out the fact that because the Constitution doesn't say one thing or anything one way or another about abortion, that is the exact solution. And that is the non-political solution, is to give it to the political branches to hash out and get the court out of the business of being what several members of the court have termed in the past the National Ex Officio Medical Board when it comes to abortion, which is clearly not a proper role for the Supreme Court.
Justice Barrett brought up the discussion of states' rights and the federal Constitution. Let's play reading the tea leaves here for a moment. Can the court actually uphold the Mississippi law without overturning Roe?
Well, certainly anything is possible. The members of the court are very smart, and I'm sure they could come up with a way to do that if they wanted to. Now, whether that opinion would be consistent with the law and really intellectually honest, I think is a different question. And I think that, if they were to uphold Casey, yet say that this law passes that muster, there really is something different going on there. They would be reinterpreting Casey, I think, because Casey says that the state may not restrict abortion pre-viability, and this is clearly a pre-viability restriction. So regardless of whether they admit that that's what they're doing, it would still involve a fundamental reinterpretation of Casey, which is why, if the court has to twist itself in knots to be able to say that it's still keeping Casey, that's just really another argument as to why they should just be honest and scrap Casey altogether.
And take everything back to the states. So redefining where and how we can restrict abortion in this country. Heather, it's so great to have you. Thank you for your analysis.
Thank you for having me.